I would like to begin by paying tribute to Hugo Kaufman. I have known Hugo for at least 25 years. We have spoken together on programs. We have dealt on many different occasions. And it was sad when I heard that he had decided to retire. We in the United States are very fortunate. Unlike Europe, where compulsory retirement varies from country to country, but is generally between 65 and 68. In the United States, since 1992, there is no compulsory retirement for professors. And I am 78, and I have 3 colleagues teaching at the law school who are older than I am. So I am delighted that we can continue, and I'm sorry that Hugo has decided to retire. I am going to talk in 4 blocks today. What I will do first is discuss the 1960s, then pause for questions, then the 1970s, pause for questions and lunch, and after lunch do the 1980s and the start of the 90s, then the 1990s until 2003. Again, with questions after each block of time. Why am I talking about the history of the European Union? This is something of a coincidence. When I was asked to speak at this workshop, I proposed the topic because earlier this year I had been requested by Takis Tridimus at King's College London to do a chapter on the historical perspectives of the European Union as the first chapter of a 3-volume EU treatise of Oxford, which will be published next year. And I expressed surprise, and he said, well, look, you are not only the most senior American legal academic in the field, all of the British colleagues active in the field who are close to that have retired. So you are the senior among active professors in the UK as well. So I thought, okay, this is a very interesting project. I've never done it. And it has required a great deal of work, and I'm still not finished. I have finished the initial parts, and that was the parts that have been sent to you in electronic version. Let me start with the 60s. Well, actually 58 and then the 60s. This required a lot of work on my part because I dare say, like many of you, I had almost totally forgotten about it. Even the 1970s I had largely forgotten about. I graduated from college in 1957. I happen to remember the signing of the Treaty of Rome, because my professor of modern European history was so fascinated by it. He was a Czech exile. And so we talked about it. Thereafter, I think I largely forgot about it until I started practicing law in Paris in 1963. And in 1965, the senior partners sent around a judgment called Grundig v. Constans. And we all looked at this. It was in French, of course. And we said, what on earth? The Court of Justice, what's this? Antitrust law in Europe, what on earth is going on? And obviously it was of great importance because if not the European clients, the American clients were very nervous about antitrust and wanted very much to comply with the antitrust rules. By 1970, I gave my first talk on common market antitrust at Zurich in a conference for patent, trademark, and copyright lawyers. By the late 70s, it had become the most important part of my legal practice. Antitrust, but also then trade law. Then when I came to visit at my alma mater, NYU in 1978, and they said, okay, you will teach corporations, you're a corporate lawyer. What else do you want to teach? I said, well, common market law. Why not? They had had only one visiting professor before who taught common market law, 1978. The only person really working in the United States at the time was the late, great Eric Stein of Michigan, who had actually published a book in 1968 on North Atlantic federal systems, which included the European community as it then was. But basically, nobody was working in the field. It only became of considerable interest to American law schools when the internal market program developed and investment in Europe became a hot topic. Okay, now going back to the very earliest period. In each of these blocks of time, I intend to concentrate on one or two of the institutions, and the two appropriate ones for this earliest time are the Commission and the Court of Justice. As I say in the text, there is a tremendous debt owed to the three founding fathers of the European community: Robert Schuman, Jean Monnet, Paul-Henri Spaak. Schuman for pushing the idea at a time when the French government was not particularly enthused. In fact, it is known that when he gave his famous speech proposing a European economic community to supplement the coal and steel community, he did so without the approval of the Prime Minister at the time, Georges Baudet. He just stuck out his head and did it. Jean Monnet was the architect of the coal and steel community and its first president, and he was therefore one of the principal architects of the European Economic Community Treaty. The other was Paul-Henri Spaak, former foreign minister of Belgium, who chaired the conference that actually worked on the drafting. And those three have been tremendously influential, because if you look at the treaty, the 1957 Treaty of Rome, and contrast it with the highly complicated text of the Treaty on the Functioning of the European Union today, you are amazed to see how much of the institutional structure and the basic substantive areas, the four freedoms, the common agricultural policy, the competition provisions, have not been changed. It is the identical text from 1957. This is truly remarkable, because we have now had well over 50 years of history, and it's still the same. And it's still the fundamental text. So they obviously worked very well in setting up the initial European Economic Community. When it was created in 1958, who knew whether it was going to be significant or not? Why was it created? Well, yes, the coal and steel community had been successful, but it was of a very limited character, and it was in what was then crucial industries, coal and steel, today minor, relatively, well, maybe not in Belgium, but generally speaking, relatively minor. But an economic community covering all of the four freedoms, agriculture, competition, etc., what will become of it? A great deal depended on the center of administration. The center of administration was the Commission. It didn't take the name the high authority of the coal and steel community, because that was thought to be maybe a little bit off-putting. Let's have a more neutral term: Commission. Commission. Commissions are all over the place, not necessarily dangerous or fearsome. What will it do? If it had been just the same type of administrative body as it had been as the high authority, what we know today as the European community and then the European Union might never have developed. But fortunately, the initial commissioners were very capable people. The initial president had the very good luck of having been a close collaborator with Konrad Adenauer, Der Alte. Der Alte. I've heard him speak. When I was a student at Tübingen, he was campaigning for his, I think, third re-election, and I heard him speak at a Kundgebung in Stuttgart. Still very impressive man. In many ways, the European community owes its development to Adenauer, because Adenauer very much wanted to push for reconciliation with France, the Netherlands, the other countries. He was willing constantly to make concessions on the part of Germany to make things work. And so in a way, he is the fourth founding father, although Germany deliberately in its ministerial meetings took something of a background position, leaving France and the other countries to take the lead. It was crucial that Germany was cooperating intensively on the project. And Hallstein was a close collaborator of Adenauer. So he had the confidence of Germany, and he was able to lead the Commission in these early years. And he had excellent collaborators. Several of the other commissioners now pretty much forgotten. But Jean Rey, for example, who developed the external relations, Mansholt, who developed the common agricultural policy, Hugo van der Groben, the competition, they were very able individuals. And the Commission developed very quickly an excellent civil service staff. This is not taken for granted. They really had to work hard at getting a core of dedicated people. And set up office in Brussels. Brussels by chance, just as Luxembourg by chance for the Court of Justice. The government of Luxembourg had a couple of empty buildings, put them at the disposal of the Court of Justice. The government of the city of Brussels had a couple of modern office buildings. What to do with them? Put them at the disposal of the Commission. This was not planned by the governments. It was happenstance. And it was only fundamentally confirmed in 1965. So they set up shop in Brussels, and the Commission gets down to work. And really, when you look at what happened, all right, the first couple of years just setting up shop. But already by 61 and 62, the two fundamental directives on free movement of capital were adopted. And this was crucially important. The free movement of capital achieved a level that it was not again going to achieve until the late 1980s. The legislative program was launched. Whether or not Spock and his colleagues intended it deliberately, we don't know. But the Commission has the legislative initiative in the treaty, and that has never been changed. The Parliament has often wanted to get the power of legislative initiative. It does not have it. The Commission does. That means that the Commission alone decides whether to put forward a draft, when to put forward a draft, make the draft, and it controls the drafting throughout the process. Yes, the Council and the Parliament amend, but then the amendments are structured within a text that the Commission proposes. And the Commission even has the power to withdraw a text if down the line it thinks it's taken a wrong turn. And it's done that occasionally, rarely, but occasionally. So this is crucially important because the Commission is also independent. The initial treaty says it. The language has never been changed. It has a degree of independence stated in the treaty that is relatively similar to the degree of independence that we regard as suitable for high courts. The language of independence of the Court of Justice is virtually identical to the language on independence of the Commission. The Commission, it is said, does not take any instructions from other institutions, notably at the time, of course, the Council, or from member state governments. And felicitously, that has been the practice. Yes, of course, there's always a little gossip. Is the French commissioner being called very often by the French prime minister or the foreign affairs minister? Is the Spanish minister running back to Madrid a little bit too often? But generally speaking, they work in independence. And of course, the meetings of the commission itself are secret. Their deliberations are not known. But over the years, enough has filtered out to make it quite clear that commissioners do not regard themselves in any way whatsoever as representing their governments, the government that appointed them initially. They may listen somewhat more often to that government, but they do not represent them. And very occasionally, there has been a crack on the knuckles administered by the president of the commission. There was a famous one in 1995 that went in the press when the then President Santer wrote a rebuke to Chancellor Kohl of Germany because Kohl was trying to push the two German commissioners on some draft directive on consumer rights. And it was published in the papers. It was in the media. So rare, but occasionally a little interference with independence, but basically independent. And that is extremely important because it means that the commission can assume an executive function, not just an administrative function. It can assume an executive function. It is responsible for the drafting of legislation. It is also, not stated so in the treaty, but certainly in the early years, the architect of the policies, the fundamental policies that underline action in the European community. Later I'll talk about the European Council and how that has to a significant extent taken over the highest level of policy making from the Commission, but during the 1960s that was not the case. So you have the great challenge of then implementing the treaty. Agriculture, today this is a Frankenstein monster. But you have to remember that in the 1950s, the initial 6 countries were not self-sufficient in agriculture. They were net importers of agriculture to feed their population. The agricultural policies that were so laboriously debated and worked through in the 1960s, and this was largely France. You know, I haven't mentioned President de Gaulle yet, but if President de Gaulle had been in power at the time of the signature of the treaty probably would never have been signed. He was skeptical of German reconciliation. I heard him speak too, unlike Der Alte, who was a small man. De Gaulle, a very tall, extremely well-dressed, polished French rhetoric, commanding presence, domineering, no question about it. But de Gaulle wanted a common agricultural policy favorable to France. And consequently, France cooperated in those early years and largely got what it wanted, principally the cereal and beef markets along the lines that France wanted. So during the 1960s, very difficult negotiations, but essentially by the end of the 60s, the agricultural markets were completely set in terms of the common agricultural policy. A great achievement at the time. It saved the agricultural sector in several countries, which was not in good condition, and it completely changed the picture. The European community by the 1970s was a net exporter of agricultural products, not an importer anymore. course, as I said today, it's a Frankenstein monster. It produces too much, the subsidies are too high, there are too many farmers, and it's very difficult to try and change that. Gradually changing, but very slowly. One of the great achievements of Parliament in the Lisbon Treaty is that it now has a say on the budget for a common agricultural policy. Has wanted it for many years. Okay, and of course in the Doha round, in the WTO, this is the most serious problem for the European Union in negotiating with the third world, with the lesser developed countries. But it was a great success back then. Competition policy. Okay, I haven't mentioned the Council, but it should be remembered that throughout the 1960s, the Council had to act either unanimously because the treaty said that, or essentially unanimously because de Gaulle wanted that. French veto. And nonetheless, so much vital legislation was adopted. Competition is a good example. Regulation 1762 lasted until 2002. The regulation was initially drafted by the Commission, and of course the Commission was concerned to get as much power as it could from the Council. The Council gave the Commission the power to set derivative rules, which the Commission began to do almost at once. The leading example, 1967, Regulation 6767 on exclusive distribution arrangements. The Commission alone could authorize exemptions, and it was flooded by literally thousands of companies requesting exemptions on particular contractual provisions. The Commission could investigate violations. It could then take a decision finding a violation, and it could set fines to penalize, and very high fines as well. As a consequence, by the late 1960s, the Commission was already vigorously attacking cartels. The dyestuffs cartel, the rubber cartel, the sugar cartel, and the like. It had become an enforcement tiger in the competition area. What else? Well, obviously the common market. The common market. It is true that the treaty provisions on the four freedoms, as interpreted by the court, could go a long way, but the Commission commenced proposing and the Council adopting directive after directive in particular sectors to try and facilitate the achievement of the common market. These were harmonization directives, in theory harmonizing the rules of the member states. In practice, quite often the member states had only limited rules in certain areas, so that the harmonization language is a bit deceptive. It was frequently creation of new rules altogether. Now, I mentioned de Gaulle, and I should speak finally about de Gaulle and the Luxembourg Compromise. Holstein was a very capable man, but a very authoritative man. Not always as polite as he ought to have been, and there are historical commentators who pointed this out. He ruffled the feathers of de Gaulle. De Gaulle famously declared, "Who has appointed that man president of Europe?" And in the fall of 1965, de Gaulle ordered the empty chair policy. For 3 months, the French ministers would not attend the Council of Ministers meetings. He was upset about several proposals, all of which, by the way, came to pass in the 1970s. The election of the parliament, a parliament share in controlling finances, and so on. And he did not want Hallstein to continue in office. So that created a crisis. And in January of 1966, at a meeting of the foreign ministers in Luxembourg, basically they agreed to disagree, but in a very polite manner. And among the things they said was that if any country felt that a vital interest was being affected by a proposal, then the proposal would not be adopted. It would be continued to be discussed. Now, the other members of the other ministers made it quite clear that this was not supposed to be an absolute veto, but France regarded it as an absolute veto. And functionally, it worked as an absolute veto until the late 1980s. When the United Kingdom joined, and this is not very well known, but the negotiators in the Parliament specifically referred to the Luxembourg veto and said the UK can use this to protect its interests. And the UK in the 1980s did exactly that. So until the late 1980s, it did have operational significance. A lot was still achieved, as I said, despite the requirement, so much was achieved, but nonetheless. Turning to the Court of Justice. The treaty set the structure for the Court of Justice, and it gave the Court of Justice competence in several jurisdictional areas. The one that they probably concentrated on was appeals of administrative decisions by the Commission. That was a natural. You want judicial review, a natural. But they picked up language that actually had not been used in the coal and steel community and created a preliminary reference procedure. That became by far the most important. Any national court or tribunal, and there's very complicated Court of Justice jurisprudence of what is a tribunal qualified to act in this regard. Any court or tribunal can send questions to the Court of Justice. They have to be relevant to the law of the European community, either treaty or secondary legislation. But the court is bound to answer. The answers, it's not said in the treaty, are binding, but it's always been regarded as the case that they should be binding. Only very rarely does a court decline to accept what the Court of Justice has said, and that is usually corrected within a very few years by the government or by the higher court. There is commentary that says that when the first reference got to the Court of Justice in 1962, they opened bottles of champagne because this was a great achievement. But already by the late 1960s, in fact, I looked at the annual reports for the 1960s, year by year, and at the back there is a statistic of Court of Justice proceedings for each year. And by, I think, 1966 or 67, the number of preliminary references outnumbered anything else. Although not many. There were usually only about 20 to 30 proceedings every year before the court. But this was a great achievement. The other jurisdictional field was also extremely important, infringement actions. The ability of the court, at the request of the Commission, to decide whether a member state government has violated the treaty or a secondary rule. And the requirement that the government then comply with the ruling, which almost always was the case. I'll talk later about the problem in the 1980s when that didn't happen. But generally speaking, always complied. And a number of those early proceedings had landmark importance in demonstrating the power of the court. But it was the preliminary reference proceedings that enabled the court to establish its major doctrines. And the two major doctrines, amazingly, 1963 and 64, 5 years after the treaty has gone into effect. Here is the Court of Justice, which probably was thought to be an administrative body principally, administrative review body, asserting fundamental doctrines that have shaped the European community. You could not consider the European community today without realizing what the court has done. First, the doctrine of direct legal effect in 1963, Van Gent and Loos. Trivial case. It was celebrated this year at a conference in Edinburgh and at the Court of Justice, and I could not attend. I was not in good health, so I could not attend. But I understand that the proceedings were fascinating, and some are going to be published in the Common Market Law Review, because they went back and dug into it, because some of the judges at the time had clerks, academic friends, and so on, and so some knowledge has seeped out. I cannot say it to my students, and I certainly cannot write it for publication, but the court was nearly evenly divided on Van Gent and Loos. It was 3-2. 4-3. 7 judges at the time, 4-3. And the Advocate General was against it. So it could have been a tie, could have gone the other way very easily. But they decided that certain provisions of the treaty had automatic legal effect, and the courts could therefore set aside government rules that did not, impaired the operation of the treaty. It's tremendously important, because the court then in later cases could say the principle of non-discrimination on the basis of nationality applies in free movement of goods, free movement of workers, free movement of services, and the like. Occasionally other provisions as well, but the fundamental is non-discrimination on the basis of nationality. And that was Van Gent and Loos. The following year, Costa v. Enel, the doctrine of primacy. Now, I'm always careful to say primacy. American lawyers talk supremacy, because that's our constitutional language. Our Constitution says supremacy. There is no reference to primacy in the treaty, and there's certainly no word supremacy. The court has asserted the doctrine of primacy in Costa v. Enel. It did so in absolute terms, without any question. It says that within the relevant field of the European Economic Community Treaty, the provisions of the treaty prevail over secondary legislation of member states, even though later in time. They therefore break down a rule of public international law that prevails in many countries. And in later judgments, the court has said, even over national constitutions. The International Handelsgesellschaft case in 1971 said that, even over the German Constitution. That is the doctrine of primacy. It has not gone without challenge. The German Constitutional Court, the Italian Constitutional Court, the Spanish Constitutional Court, the Polish Constitutional Court have all said that, well, if ever the Court of Justice does not protect basic rights sufficiently, and those rights are guaranteed in our Constitution, we will step in. That has never happened, but it is a caveat that those courts have always stated. The German Constitutional Court, because Germany is a federal state, adds, likewise, if there is anything that is granted by our Constitution to the states that is being interfered with by a provision of the Treaty of the European Union today or a court judgment, we will step in. That likewise has never happened It is known that the Constitutional Court of Karlsruhe in Germany and the Court of Justice entertain close relations, that the German judge on the Court of Justice is supposed to go regularly and confer with colleagues at the Constitutional Court, that they are very keen to avoid any conflict. But those caveats do exist. There was a proposal to put a provision on primacy in the Treaty of Lisbon. That didn't happen. There is merely a declaration annexed to the Treaty of Lisbon, which says essentially, it was drafted by the legal service of the Council of Ministers, and they gave an opinion on it. It says essentially that the case law of the Court of Justice is respected. That's all. Okay, I think I have spoken long enough. Let me pause to take any questions that you might have or comments that you might have, because I know some of you, like myself, were young and frivolous back in those early days. The treaty provides, and it has never been amended, the treaty provides that the Commission can act by majority. So it is known that the Commission prefers quasi-consensus. I won't say consensus, quasi-consensus, a general agreement. But it is also known that the Commission occasionally takes votes. Now, that's all that we know, because deliberations of the Commission meets usually once a week. And it's usually an all-day meeting. Has an awful lot to be dealt with at that level. The Commission rules of procedure, which I read, they are periodically modified. They were modified after the Treaty of Lisbon, says that the President of the Commission can not only chair the meeting, but call for a vote. That's all we know. That's all we know. It can be assumed that for any difficult decision, the Commission would be unlikely to move ahead, say on a draft of legislation or the decision to sue a member state. It's unlikely to move ahead if one or two commissioners are very much opposed. But it can. It can. So now, is it unwieldy today? That's something I would have reached this afternoon. But very quickly, the Treaty of Nice, when they were foreseeing the addition of so many new member states and so many new commissioners, was worried, the drafters were worried about the Commission becoming unwieldy, and it therefore proposed something that is also in the Treaty of Lisbon, carried over into the Treaty of Lisbon, that before 2014, the European Council should reduce the number of commissioners. And the idea was they would reduce it to about 2/3, and then they would rotate. That is not going to happen. That is not going to happen because it was difficult to try and obtain the ratification of the Treaty of Lisbon in some states, and particularly in Ireland. The Irish wanted a commissioner. The most small states want to keep a commissioner. Ireland was in a position to block because the Supreme Court of Ireland said you had to have a referendum. The government of Ireland said the referendum will lose unless we get a commissioner. The European Council, therefore, twice has said this provision will not be carried out. All states will continue to have a commissioner. The provision is in the treaty. The treaty, therefore, has to be amended. One thing that I have neglected to do is to see whether the accession treaty with Croatia amended it. There had been talk about putting it into the accession treaty of Croatia. If not, it will have to be amended by the European Council, and I guess they have now a simplified revision power under the Treaty of Lisbon, and it might be amended through that. But in any event, every country is going to keep a commissioner. That will make, as you quite rightly say, it more difficult. One obvious consequence in the modern commission is the power of the president is enhanced. Because of necessity, some things now have to be dealt with by the president alone rather than waiting for the entire commission to work. And of necessity, the power of the chair in a large body is greater than the power of the chair in a small body. So, tribunal is if you will, a term. It's not a legal term as such. It is a everyday term that is used most commonly for administrative review bodies. Okay, so a tax tribunal, a tribunal to review assessments on real estate, all of these things. A review body, traffic, well, we call them common traffic courts in the US, but they're really administrative tribunals. And there are a tremendous variety of them. The problem for the Court of Justice is that it has a very complicated doctrine on distinguishing a tribunal where there is independence of the persons who sit, and where they have rules that they have to apply, and it's not purely discretionary, they're bound by rules, plus they deliberate and issue decisions that have to be formal in character. That is, from the Court of Justice point of view, a body that can send a question to the Court of Justice. If it is purely discretionary, if it's one person dealing with the matter, as so often is the case, the tax inspector reporting to a tax superior, if there is no obligation to respect rules and issue a decision, that's not a tribunal for the purpose of referring questions to the Court of Justice. And you are certainly not stupid, because the Court of Justice gets these questions every year trying to decide whether one body or another is a tribunal, and it's very tricky. In 1958, they started creating directorates general, and that's the technical name they give to large departments that parallel the operational fields of the European Economic Community and now European Union. Mm-hmm. The number has varied over the years. And recently, there have been more commissioners than there are directors general. I'm not absolutely sure of the total number right now. I think it's 21. But there might have been a reshuffling recently and I hadn't paid attention. So that means some commissioners do not have a director general. They have other administrative responsibilities. There is, therefore, a commissioner responsible for the translations and interpretation service, which is a very large service. It's the largest single service of the commission. It represents close to 2,000 people, because there are 22 official languages. A commissioner may be given a specific portfolio. There is someone responsible for personnel, for example. So they are given a particular, and when the Central European enlargement was going on, there was a commissioner responsible for the enlargement negotiations. Did not, therefore, chair a particular department. So there are possibilities other than heading the Director Generals. But most of the commissioners have a Director General. So one is responsible for external relations, one for agriculture, one for environment, one for, well, energy I think is not a separate one, but they're grouped by fields. Well, that's the view of the Court of Justice, and it is said so now 3 times in judgments. The leading judgment being the Opinion 192 on the European Economic Area Agreement. The Court of Justice refers to the treaties as constitutional charter, as a constitutional charter. And as you will recall, in the middle of the decade, 2000-2010, in the middle part, a treaty establishing a constitution for Europe was drafted and open for ratification, and a majority of states ratified. But unfortunately, France and the Netherlands decided to proceed by a referendum. And the referendum in France was narrowly adverse, and the referendum in the Netherlands was decisively adverse. So that treaty could not be ratified. One of the reasons why the referenda did not succeed was because it had too many trappings of a constitution. The term constitution was used, a treaty establishing a constitution for Europe, and it was thought that this was injudicious. The Treaty of Lisbon, however, is essentially the constitutional treaty without the language. A few fine-tuned provisions, but basically it's the same. It has been called by authoritative commentators, Paul Craig, for example, at Oxford, who's a leading British commentator, old wine in a new bottle. It's essentially the same thing. And there's no question that it's essentially the same. You go down provision by provision, and it is the same thing. So the court calls it a constitutional charter. It is an extremely complicated and detailed treaty, far more complicated and detailed than many national constitutions. Back in Van Genten, Loos, and Coste v. Inel, the court talked about it being a new legal order and said it represented a cession of sovereignty to a central organ, central institutions. That is undoubtedly true today. What do you call it? Well, you know, if it walks like a duck and talks like a duck, what is it? I grant you that lawyers, or law professors, I should say, who know something about the system and respect the Court of Justice are perhaps more susceptible to talking about it as the equivalent of Constitution than political science professors would. It is something of a difference in optic. I guess there is no conclusive answer, and there won't be, because there will never be another attempt to have a constitution for Europe. But if you look at the tremendous transfer of powers, as a pragmatist, I think the answer is yes, there is a constitution. One of the interesting issues is, can you get out of it? And the Treaty of Lisbon for the first time says you can. A member state can withdraw. It had been debated before. Under public international law, the answer was clear, yes, you could. But now there's a specific treaty mechanism. I was a young lawyer in Paris when he was elected. He had, anecdotes are sometimes interesting. I was a young lawyer in Paris when he was elected. It was a big surprise. Pompidou very sadly died of cancer, and a very painful cancer too. And he was a great man for France and for Europe. He died. Who's going to succeed him? Nobody had planned this. The principal candidates were the former prime minister and the former defense minister, and Valery, who had been a second-tier minister. But Valery was young and had charisma. And to everybody's surprise, he won. Giscard d'Estaing, that impossible name, Giscard d'Estaing. And he was actually a very successful president for France for 7 years. He was a liberal centrist. He was hard to classify. He was not far right, he was certainly not far left. And he knew how to bow and tack. But his last prime minister was very unpopular. And you're going to laugh when I tell you who his last prime minister was. Chirac. Chirac. And so Mitterrand won in 1981 in the presidential elections. Very surprising. First socialist since before de Gaulle. Very surprising. But Mitterrand won and then served 2 terms. And of course was succeeded by Chirac. But Valery Giscard d'Estaing continued to head a smaller party in the French Parliament and became a member of the European Parliament and a very active member of the European Parliament. And when the proposal came for a convention to draft a new treaty, the European Council had called for this, and it had said several things should be introduced in the new treaty, which were seen as an invitation to draft a constitution. Giscard headed the convention. Now, the convention had been successfully used for drafting the Charter of Rights, and we'll talk about the Charter of Rights later. It was an idea that came from Germany and was implemented by the Finnish government, which held the chairmanship, the presidency at Helsinki when the convention was set up. And the convention was so structured that the European Parliament had the largest single delegation. And every national parliament had a small delegation. The Commission had 1 commissioner. The governments, of course, had 1 representative, but the structure of the convention was clearly one dominated by the parliamentarians. Now, arguably, that was absolutely fine when you were drafting the Charter of Rights. Arguably, they were most sensitive to democratic needs and most sensitive to protection of rights. But when it came to drafting something that was going to replace the current treaties, arguably, this was not the way to go. The convention that worked on the new treaty structure took, 10 months, something like that, a long time. And initially, it was really quite disorganized. There were all sorts of proposals coming in. And basically, it was drafted by Giscard and a handful of people who were called the Presidium, a group, I can't remember, I think 12 who constituted the Presidium, and then presented as pretty much a fait accompli to the entire convention, which accepted it. There's an extremely critical book written by a Finn who was a member of the convention, saying this was, this is an utterly undemocratic way of trying to create a constitution. But that was the document that was then presented for ratification. And as I said, a majority of states ratified through their parliament. And Spain ratified by a referendum easily. And now I'm talking from memory. I think a couple of the Central Europeans ratified by referendum. I think Baltic states ratified by referendum easily. But France didn't need to. France did not need to. That was a terrible miscalculation on the part of the French government. Whether the Netherlands needed to, I don't know. They hadn't done it before for either Amsterdam or Nice. So I'm not sure they really needed to.
Perplexed. I didn't recall it.
Yeah. You know, Ireland has to because their court requires it. Denmark as a political necessity. The court has not said that, but the Danish parliament has made clear that they will not ratify. It has to be a referendum. But it never reached that because France and the Netherlands said no. And then there was the so-called period of reflection for 2 years in which the European Council said we're not going to do anything. And the mover and shaker that made it happen was Angela Merkel. The German government, well, first, before Angela Merkel stepped in, Bertie Ahern, is that a name that people know?
Yeah,
Bertie Ahern, Prime Minister of Ireland. Very determined Europeanist. When Ireland had the presidency under Ahern, he personally went around to nearly every capital to discuss the possibility of getting it launched again, getting some effort undertaken. And so the groundwork was laid. Then Germany takes over and Merkel says, period of reflection is over, we should act. And very quickly, they simply took up the draft treaty establishing Constitution for Europe, removed some constitutional stuff, tinkered a bit with some provisions, and it went through. It went through. But neither France nor the Netherlands had a referendum. At the time, the newspapers said there were two major reasons why the referendum was adverse. And it was not overwhelmingly adverse, it was narrowly adverse. The first was the picture of the Polish plumber. Because the Central European states had just come in, and although the treaties provided for a 7-year transition period for workers from the Central European countries, this was modeled on actually the Spanish, Portuguese, and Greek accessions because they had likewise, in fact, they had a 12-year period. But what happened back then, it's very interesting because I was teaching already in the 80s, I was following this. It's very interesting. There was a net return of Spanish, Portuguese, and Greek workers to the home countries after they joined, not a net migration. And consequently, the Commission and the member states felt more comfortable about having the 7-year period. But nonetheless, a 7-year period within which each country could decide, first 2 years, then 3 years, and then a final 2 years, but with Commission approval. And Commission only approved the final 2 years for Germany and Austria for obvious reasons. They are the adjacent countries. They had by far the largest number of immigrants from the Central European countries. In any event, the Polish worker publicized in France, there are all these blue-collar people going to come and take our jobs, and that resonated quite a bit with the French population. The other was that the French government made the terrible mistake of translating the treaty into French and sending a copy to every household in France. Terrible mistake. You do not have a referendum when you send a thick document to people who have no capacity to understand it. So those two were critical. There were others too. The government was unpopular. Anytime you have a referendum when the government is unpopular, you're going to get a lot of no votes just because the government is unpopular. This was particularly true in the Netherlands. So you have a confluence. But you can call me undemocratic if you will, but I think that referendums should never be used. Never be used. For that reason, because the population at large cannot. I am a Burkean. You know this great debate between Burke, the English great member of parliament in the late 18th century, and Rousseau, the French people should speak. Referenda came in through the heavy, in the United States, came in through the heavy influence of John Stuart Mills in the late 19th century. Now, you political scientists should know John Stuart Mills and his influence. But a number of state constitutions were then amended, particularly the newer states, all of the western states, Illinois, and so on, to provide for easy referenda. They also created some other problems of a legal nature that I won't go into right now. But as a result, California has, I don't know how many referenda every year. And the classic occurred in the 1990s because it's easy to get a topic on the ballot. And whether the voter, when the voters are only voting yes or no, it's easy to word that topic in a fashion that makes it more appealing for a yes vote. On the ballot in California in that year, there was a measure for an environmental, for something that had environmental consequences and con, and they both passed. I don't know what the legislature did, but it's typical. New York State, we have virtually every year something amending the Constitution. Does anybody know what they're voting on? I look at the New York Times, what it says, I vote. I don't know. I admit I took my own decision on the retirement age for the Court of Appeal. But otherwise, yeah, I have no idea. A bond issue, is it good, bad? I have no idea. What does the Times say? Vote. Because really, representative democracy, that's why we elect people. So I'm sorry, but, and I'm sure it is viewed as undemocratic, but I will tell you, I mean, before John Stuart Mill in the 19th century, this didn't happen. Is this a federation or is this not a federation? The word federal cannot be used because the UK opposed it. It was the F word that the UK would not accept in the Treaty of Maastricht in 1993. But how far has the operational structure gone in interfering with governmental powers of the constituent states? Okay. Court of Justice says primacy, and basically within the context of the treaty, within the competences of action of the treaty, that's accepted. The constitutional courts having only a limited caveat. But how far does that go? And the answer is not a simple one. And different people can, I think, disagree pretty fundamentally on that. I am publishing right now an article in the Columbia Journal of European Law. And the title goes to your question. The title is Supranational, question mark, Federal, question mark, Intergovernmental, question mark, an examination of the European Union. And I reviewed the various institutions and discussed to what extent each is intergovernmental versus supranational versus federal. What I can say is quite clear that the intervention in substantive law terms of legislation adopted by the European Community, now the European Union, usually in the form of directives, hence harmonization. The intervention in substantive law terms is greater than the intervention of federal legislation in the United States today. It has become extremely difficult to adopt federal legislation today. And whatever the president, not a great deal is done that is novel in the way of federal legislation today. This is not true in the European Union. I haven't got to the later periods, so we haven't reached topics such as employment law, environment law, consumer rights, etc. But the degree to which common legislation has been adopted, the entire internal market program of common legislation in company law, in banking law, in other fields, it's unthinkable in the United States. As a law professor, I can tell you that what we do is we have model laws adopted by the commissioners for uniform state laws and then adopted at will by states. The Model Corporation Act, Model Penal Code, etc. And we have what are called restatements of law, developed by the American Law Institute, trying to give guidance to courts in particular fields of law, tort law, contract law, property law, and the like. Because you cannot deal with this at a federal level and establish the rules in that manner. We can't do it. Consequently, it's a very complicated answer because pragmatically speaking, a lot more is not uniform, it's harmonized, but structurally very similar in the law of European Union states than in the United States. So I would certainly never say it's a veneer. It really has tremendous operational significance. And that is too little appreciated today in the United States. I mean, the study of European Union law and European Union governmental structure and so on has just dropped enormously. You know, when I was teaching in the 1990s, the height of the internal market enthusiasm, my class size ranged from 60 to 100 students, an average 60 to 70 every year. Comes 2000, it starts to drop. Last fall, I had 20. Next January, it looks like I'm going to have 20 again. Why? The Euro crisis. Monetary union is going down the tubes. Well, the European Union is presumably going down the tubes too. The students read the papers, and that's the misleading impression in the papers. Now, the corporation's no different. The European Union is by far the largest investment center for large American corporations, considerably ahead of China. So the corporation's no different. And the big law firm's no different. But the students don't. And I don't know what is the the experience here among political science and international area students, but that's true at the law schools. In 1969, de Gaulle is gone. He miscalculated. He had a referendum in France and he lost. So he retired. He resigned. His prime minister, very fortunate for France, very fortunate for Europe, was Georges Pompidou, former French finance banker and quite an expert in that area. And Pompidou called a summit meeting that was held in The Hague in December of '69. By a happy coincidence, the German chancellor was relatively new. It was Willy Brandt. And certainly Americans of a certain age know Willy Brandt. He was a great man for Germany. He had been the mayor of Berlin, the first socialist chancellor, very open towards European endeavors. And the other persons at the meeting, the other prime ministers at the meeting, were likewise open to new ventures. The crucial issue, there were a number of issues that were before them. There were technical agricultural policy fights and so on, but the crucial issue was the UK, Denmark, Ireland, and Norway had applied to join. Now, de Gaulle had vetoed these accessions, but he was gone. So what should be done? And the crucial decision at The Hague was, yes, they can join, but the French government, it was actually the phrase of the foreign minister at the time, said they can join on the basis of the acquis communautaire. Now, acquis communautaire is in the treaty now, but it is never well translated into English. The commentators never translated into English or Dutch or other languages. It's usually just put as acquis communautaire. I dare say the official languages must do something about that, but not the everyday. What is the acquis communautaire? What we have, you can't challenge. And the three aspects of the acquis communautaire is you don't try to amend the treaties, you don't try to amend the fundamental policies, you don't try to amend the legislation adopted. All right? That was the acquis communautaire. And that meant that the UK, Denmark, Ireland, and Norway were negotiating only on minor aspects. They couldn't change the fundamentals. It was particularly annoying to the United Kingdom and Ireland because the agricultural policy had not included a fishing policy. But it was on the drafting stage, and they were told they couldn't change what was being planned. Now, both Ireland and the UK have large fishing fleets, and they were not happy about this, but they had to accept it. Another thing that annoyed the UK very much was they had to adopt a value-added tax. And by George, unless you're European and understand a value-added tax, I have no intention of trying to tell you what it is. So that was a crucial development. And it was so successful that the heads of government decided, well, let's do this again. They had a not very interesting one at Copenhagen. They had a not very interesting one at Paris. But in 1974, now the other countries are now in, they had a big one at Paris. And it adopted a couple of crucial decisions too, the most important being direct election of the parliament. Parliament in the initial treaty was the assembly. It was a purely advisory body. it had no power. And of course, it is immediately demanding power. And democratic credentials by being elected instead of just being sent by delegations from the member states. So, crucial decision, go. This will happen. Took a long time. It was complicated. Had to decide how many members of parliament from each country, had to decide how the elections were going to be held, same time for the elections, proportional representation or not. Not easy. So it took actually until 1979, June of 79. But the decision was taken. So Valéry Giscard d'Estaing, with his typical rhetorical flair, says, we shouldn't call this summit meetings. We should call this the European Council, the Conseil Européen. And we should meet regularly. At London in 1977, they decided they would have at least 2 meetings a year. It's now 4 regular sessions. March, June, October, December. And we should be talking about not only basic policy, but also international affairs. And hence, the London meeting said, we will do something that became known as European political cooperation and later the common foreign and security policy. We will adopt statements on international issues. So since 1977, every meeting of the European Council has a series of statements which presumably are not really debated. The General Affairs Council of the Council of Ministers, that's the Foreign Affairs Ministers under a different name. The General Affairs Council prepares the meetings of the European Council and prepares all of these statements. And although we know very little about internal discussions at European Council meetings, usually they're just, the statements are just issued. Occasionally a statement is not issued. Somebody has objected, but usually they're just issued. And most of them are fairly innocuous statements about international affairs. I say innocuous, they have, in many cases, a certain persuasive effect. For many years, the European Council, like many in the US, was decrying apartheid in South Africa. When the Soviet Union invaded Afghanistan, virtually every session thereafter would decry the invasion of Afghanistan. When the Central European countries started to become independent, support for them, et cetera, et cetera. So having a certain resonance in the press, but basically not controversial. Now, once the European Council had decided that enlargement was possible, before the end of the 70s, we have Greece, Spain, and Portugal becoming democracies. Spain and Portugal, the fascist governments are gone. Terrible time in Portugal, nearly a communist. Does anybody remember that? They had briefly a communist government. And there was great fear that it would go communist permanently, but then it was ousted. Spain also had a great deal of difficulty. In Greece, the colonels, it was not fascist, it was the colonels that ruled, and they were ousted. Naturally, they want to join. Who decides? The European Council. The European Council authorizes the negotiations. The process of accession in the treaty does not refer to the European Council. It does today. The Treaty of Lisbon for the first time says the European Council should give its views. But it doesn't say that it's determinative. But in point of fact, everyone knows it is the European Council that is determinative. The Council of Ministers must decide unanimously, but they would never decide unanimously unless the European Council said go. The Commission must give a favorable opinion, and that is crucial that the Commission give an opinion, but the Commission opinion does not have to be followed. In point of fact, the Commission opinion on Greece was, it's not yet time. But the European Council and the Council disagreed. Valéry Giscard d'Estaing was pretty much instrumental in that, by the way. He was a great lover of classic Greece. And return to democracy in Greece, definitely Greece should come in. So, again, the basic decision being taken. Greece actually came in pretty quickly, 1981. Spain and Portugal took a lot longer, 1986, because of agriculture and fisheries and free movement of workers. Those were the two big issues that were confronting them and negotiated for years. And the European Council had to intervene once or twice and say, now let's cut and go. Okay, so that's why I talk about the European Council. The European Council also started taking some other decisions of a great importance. The Declaration of Democracy of Copenhagen of 1978. Has anybody heard of the Declaration of Democracy of Copenhagen of 1978? You've probably heard about the Copenhagen criteria for the Central European countries of 1993. But that built on the Declaration of Democracy of 1978, coincidentally at Copenhagen. Actually, it may not have been a coincidence. Remember that the president of the European Council is a 6-year rotating process until the Treaty of Lisbon. And some countries have greater interests in particular fields than others. And Denmark is always very much concerned with basic rights and democracy. So it is probably not coincidental that it was that Copenhagen European Council that said this. And what did they say? They said that any member state must be a functional representative democracy with the rule of law, and that was a condition for membership. Whom were they talking to? Greece, Spain, Portugal. They were saying you cannot go back. You cannot change. Once a democracy, always a democracy. Okay? So a statement of the European Council of great importance that is not international policy. It is very much attuned to what you have to be in order to be a member state. And later, of course, implemented by treaty provisions, the current Lisbon Treaty provisions on democracy, traced back to this. The European Council was also instrumental on another front. In the late 1970s, for the first time, it was possible to consider monetary coordination. Here you have to go back earlier in time. Does anybody remember the gold standard and the US dollar backing the gold standard? When I was young, that was the case. Of course, the Brits had gotten out. Before World War II, it was the British and the pound. But after World War II, they were no longer the leading monetary power. It was the US. And at the famous Bretton Woods Accords. Bretton Woods is a beautiful big hotel up in New Hampshire. And the Western countries' leadership, finance leaders met there and adopted the worldwide monetary accords that provided for stable exchange rates. And it was backed by the US dollar, and the US dollar was backed by all that gold in Fort Knox. And in downtown Manhattan, way below street level, in the Federal Reserve vaults, there are billions in gold. But most is in Fort Knox, hence Goldfinger. Now, that worked very well for many years. When I was young, and a young law student in Germany and a young lawyer in Paris, you knew dollar equaled 4.9 marks, dollar equaled 4.8 francs, dollar equaled 4.3 Swiss francs, dollar equaled, or the other way around, pound equaled $2.80. That was it. That was extremely stable. 1969 crash. 1969 crash. More and more speculative investment movements on world financial markets, and the dollar cannot resist anymore. President Nixon takes the dollar off the gold standard and says the dollar will no longer be the world reserve currency. Crisis. Floating rates established. In Europe, this hit hard. And because fixed rates within the European community meant stable transactions. Floating rates meant businessmen didn't know what to do. I was a lawyer then, and you had terrible contract provisions on alternate currency and duplicate alternate currency and insurance provisions and the like. It was terrible. 1970, the Council of Ministers commissions the Warner Report. We should have a monetary structure. 1970s, the energy recession, following upon the 7 Days War, and the hiking of oil prices. Worldwide energy recession, nothing can be done at the monetary level. Beggar your neighbor is the policy of governments during this time, each for himself. Okay, into the 70s, things have calmed down. Nice confluence. Who is the president of the commission? Jenkins. Who is Jenkins? Jenkins was an unsuccessful candidate for prime minister of Labour Party, chancellor of the Exchequer, sent to the commission as the first UK president, expert in finance. Who is the prime minister of France? Valéry Giscard d'Estaing, who had been the former finance minister. Who is the chancellor of Germany? Schmidt, the former German finance minister. These people know finances, and they conclude it is possible to work towards a European monetary system. So at Bremen and then at Hanover in 1979, the European Council says, go. Create a monetary system. The monetary system then created, went into effect that year, held until the monetary union started to be developed in the 1990s. Treaty of Maastricht provisions. It was largely successful. It established an exchange rate mechanism, so-called, an ERM, that said the rates will only float within a very narrow band. The band was plus or minus 2%. And if French francs and German marks got out of the band for more than a couple of days, then the governments had to intervene and change the rates, which happened twice in the 1980s, but not radically. German mark always goes up, never down. Anyway, there was a common reserve of currencies to help stabilize the system, and it works, as I said, very well in the 1980s. So this was the last great decision of the European Council of the 1970s. What's the Court of Justice doing? That's the other body I want to talk about in the 1970s. Yeah, the Commission, the Council, very active. A lot of important legislation adopted. In particular, before I moved to the court, employment law, social policy and employment law. The internal market did not, and the common market did not as such include social policy. It's mentioned in the treaty, but there's nothing that provides for legislation, with one single exception: equal pay for equal work for men and women. Very bizarre treaty provision, inserted at the demand of France, because France had a constitutional provision to that effect and nobody else did. And French industry was concerned that they would have to pay higher wages to women and other countries' businesses would not. So it's in the treaty, but that's the only thing. But in 1974, the Commission and the Council adopt the first social action program. And in the 1970s, they start adopting legislation, the most prominent of which is equal rights for men and women in conditions of employment. And that means not just pay, but everything else: hiring, firing, workplace conditions. That's a radical change. That's a tremendous change. And it occurred in 1976. Similarly, environmental law. An action program for the environment starts in the 1970s. And an action program for consumer rights. Now, why aren't they in the treaties? Why didn't the treaties in 1958 have? Nobody was talking about the environment or consumer rights in 1958. Not in Europe, not in the United States. Nobody. In the US, it came in the 1960s. In Europe, it comes in 1970s. So without treaty provisions, we have action plans and legislation. Legislation often had to be adopted through the so-called elastic clause, a final provision, Article 235 in the treaty, which said that if the Council of Ministers thinks there's something that's desirable to achieve an objective of the community, it can do so by unanimous vote. And hence they were adopting these measures by unanimous vote. Starting in the 70s, I wrote an article on consumer rights. It was published, I think, in '83, Consumer Rights in Europe. And the irony is, what happened in the US in the 1980s? You probably know this. What happened in the United States in the 1980s?
Ronald Reagan.
We got a new president. We got a very conservative president, a charismatic conservative president, Ronald Reagan. And what happened to environmental policy and consumer rights at the federal level? It's gone. And it's never come back. It has literally never come back. A little bit in the Clinton administration. And we have now the Consumer Policy Commission. But basically, it's never come back. Most of the activity in environmental policy and consumer rights is at the state level: California, Washington, Massachusetts. In Europe, on the other hand, once the policy programs were adopted, the next step is to put it into the treaties. And it came into the treaties in the Single European Act and the Treaty of Maastricht. Okay, back up again. Court of Justice. In the 1970s, although harmonization was continuing in some areas, other areas were really blocked. They couldn't achieve progress. The Court of Justice is often criticized, particularly in the UK, for being activist. And I think that's absolutely true. It is activist. The only question is whether that's good or bad. The court doesn't like the term. The court likes to say that it is teleological, which is a nice, complicated Greek origin word for purpose-based. And it says it looks at the treaty and looks at what the treaty provision wants to achieve. And if it wants to achieve something, the court can interpret it, can interpret legislation to achieve that goal. In the early 1970s, the court had two cases. One, the right to provide services across frontiers. The other, the right to establish oneself or business enterprise in another country. The council was deadlocked. Well, not deadlocked. The council couldn't reach unanimity. What does the court do? Direct legal effect of the treaty provisions. The Reiners case and the Van Binsbergen case, both 1974, 4 months apart. Direct legal effect, right to provide services without restriction on nationality, right of establishment without restriction of nationality. Not only did this mean that there were cases afterwards to apply, but the council was unblocked. If the court is going to say this, we better get there and harmonize with legislation before the court does something we really don't like. As a consequence, for lawyers, delightful. The Lawyer Services Directive, 1976. Lawyers can now provide services throughout the European Union. Other directives in different fields that established the ability to move. And of course, later in the internal market program, this becomes a major aspect of the internal market program. So the Court of Justice unblocks. In the social policy area, the famous Dufresne case. Has anybody heard of Dufresne? 1974 also, the Dufresne case. Mrs. Dufresne was an airline stewardess. Mrs. Dufresne, at the age of 39, is fired. Well, she's retired. She's retired. If anybody here is scandalized by that, that was the policy in the US as well. Airline stewardesses were supposed to be young, attractive, appealing. People like that. Retirement at 39. Men can keep going, all right? Clearly discriminatory. Can you do anything about it? The answer at the time, because Mr. Friend had a women's rights lawyer, and they fought. They bought 3 different cases. And she lost on firing. That was one of the reasons why the Equal Opportunities Directive was adopted in 1976. So that after the directive went into effect in 1978, you couldn't fire a woman stewardess when you kept a man on. Couldn't do it. She won on equal pay. She didn't win on back pay. And the case was Dufresne. And the Court of Justice in Dufresne said, notably, social policy is a fundamental goal of the treaty as well as economic policy. All right? And that put the blessing on the social and employment policy programs of the 1970s, and also later for the introduction of specific legislative provisions in the Treaty of Maastricht. Okay, so the Court of Justice, once again, activist, if you like, teleological. There is a history, by the way, of the European Union. It's called Europe Recast by Desmond Dinan down at George Mason. He's a political scientist and historian. He trained as a historian. He's Irish. Came to the US as already a professor. And he wrote this book in 2006, Europe Recast. It's a small publisher out in Colorado, so it's not easy to get a hold of. Lynn Riener, L-Y-N-N-E-R-I-E-N-N-E-R, Lynn Riener. I ordered it specially, and he has another book that is 2010, which is called A Closer Union, which is a institutional and policy book about it. In any event, he is the leading English language historian. There are a couple other earlier histories that I know. Hugo van der Groben wrote a very early book, and a British professor called Derek Unwin, I cite them both, wrote a book in the 1990s, and Lord Cofield wrote his own book about the internal market program. So there are other sources and there are articles, but Dinan is by far the best. COREPER was created immediately. How many, I don't know. But there's a very valuable book on the institutions of the European Union by Wallace and a hyphenated name, something Henschel. Helen Wallace, British political scientist and a colleague of hers. At any rate, they say that it was already extremely active and influential in the early 60s. The council doesn't have 15,000, but it has 4,000 people working for it. It has a secretariat, which is a general secretariat, and then it has working groups divided by directorates. Now, it doesn't have as many as the Commission. I don't know how many it has, 4, 6, 8, whatever. It has its own legal service, it has its own translation service, it has its own information service. And it's obviously essential that the council have all of this because the council is with the parliament, the legislator, for most legislation, and in a few fields, the council alone. Tax, council alone. Competition, council alone. Monetary union, council alone. So it has to have a lot of very sophisticated people. I know some of the council legal service people just as I know some of the commission legal service people. The COREPER is the highest body. Now, COREPER is outside that secretariat structure that I mentioned because it is composed of representatives of each nation at the ambassadorial level. And their deputies are deputy ambassadors. There are two groups. They meet simultaneously, separately. The political group, the economic group. Exactly where they cut the line, I don't know. They meet at least weekly, and sometimes more often. They do what? 90% of the work of the council in legislation? Only when COREPER reports it up to the council does the council look at legislation, the ministers themselves. And the COREPER reports it up on A points and B points. A points are when the COREPER has agreed You can now adopt this, or here are the aspects on which we are in agreement. B points are when the co-repair cannot agree but thinks that the council might be able to, because it's tough, but the council has the power. So it throws it up, A points or B points or a mix, and the council then acts. And sometimes it's final and the council pushes out, and sometimes the council says, okay, go this route, sends it back down, and sometimes the council can't agree and sends it back down and says, keep talking. So that's co-repair. Political scientists who have reviewed attentively co-repair, and I obviously have not, believe that it takes on a very European cast. They're in Brussels for long periods of time. Foreign ministers change. Foreign ministers have to reflect government attitudes. Co-repair can take a more European view. Hence, it's very functional. It can achieve a lot. And that enables legislation much more easily to be adopted. Or what the council alone can do?
Yes.
Well, the most important is taxes. And that could be either internal or direct, but in point of fact, they have never done anything on direct taxes and are never going to do anything on direct taxes. It's far too sensitive. Internal taxes, the two are value-added tax and excise taxes. And already in, when was it, 72, 76, there is a value-added tax harmonization directive. It is enormous. It is so technical. I haven't looked at it in years. Because it's harmonizing value-added taxes in product and service area after service and product area. But all it does is detail how you what is appropriate for that product, what service. The rates are within the discretion of the government, and all that they have been able to do is adopt, I think most recently in the early 90s, bans. So that you can have a luxury tax, which is on jewelry and expensive perfume at the highest band. You can have the common product and service, which is the intermediate brand, which is I think 16 to 18%. And then you have the food products, which is a very small, and I don't remember now whether you can, I think you cannot put value-added tax on books and newspapers. I think they're out. But at any rate, that's all. Whether the government chooses 16% or 18%, 22 or 28 for the luxury, it's up to the government. They cannot harmonize that beyond the bans. Excise taxes, exactly the same thing, bans. Now, what are the principal excise taxes? Well, you all know that in the US. The principal excise taxes are alcohol, tobacco. Alcohol and tobacco. Can be jewelry, can be some other products, but those are the two. And again, all they can do is bans. They cannot do more than that. And direct taxes, out of the question. But if any action is taken, it has to be the council, not the parliament. Parliament has no say. Curiously, from my point of view, curiously, competition, antitrust, council alone. Until the Treaty of Lisbon, agriculture. But now the Parliament is in the tent for agriculture. Monetary union, any legislative power, there are a couple of exceptions. The Parliament, and this is actually important currently, If the central bank gets legislative power over prudential supervision of banks, the parliament has to be joined in the legislation. I mean, that's actually going on right now. They have actually adopted it and they're currently implementing it. Am I forgetting something? Oh, yes. There are some aspects of employment law that can only be adopted by the Council, and they're highly unlikely of being adopted. What are they? A couple of things that nobody can do. Establish a minimum wage for the entire European Union. You see currently in Germany the controversy. They can't do that. They cannot establish a minimum wage, and they cannot intervene with legislation concerning strikes, regulation of strikes. That cannot be done. But there are a couple of others that the Council alone can do, and only unanimously, and I can't remember right now what they are, but not important. Taxation is important. Competition is important. How do you get to work for the Commission, the Council, or the Parliament? Or for that matter, for the Court of Justice at secretarial or other level. No, secretaries would not be, they're not professionals. Any kind of civil servant status, they have what are called concours, competitive examinations. And they have them periodically when they have a demand to fill in a particular sector, in a particular directorate general. Number of vacancies have developed, okay, it's time for a concours. Legal service, time for a concours. When the Central European states came in, concours all across the board to try and recruit. Those are extremely difficult examinations. Periodically, I have an LLM student who wants to do the concours, and in addition to the studies, they usually bone up on a lot of other things to try. And of course, you have to have at least French and English. At least. You cannot get in unless you are fluent in both French and English. And preferably at least another language. The 1980s. The 1980s did not begin auspiciously. This was significantly, I won't say largely, but significantly due to the election of Margaret Thatcher, the Iron Lady, as Prime Minister of the UK. She was not enthused by the European community and not disposed to have it develop any further. Another factor, Jenkins was not reappointed. Obviously, he was a socialist, and she was not about to appoint a Labour Party man. But in addition, none of the other governments had a big, influential official to name as Commission President. So, little Luxembourg offered its prime minister, Gaston Thorn. And Gaston Thorn, whatever his abilities, simply did not have a heavyweight capacity to influence the governments. So the early 80s, not much actually happened in the European community, and it's often referred to as a period of Euro-pessimism or Euro-stagnation. It is true that President Mitterrand was a thorough advocate of European community action. But Chancellor Kohl, elected for the first time in Germany. Mitterrand served 2 terms, 81 to 95. And Kohl served actually 3 terms, shorter terms. But Kohl initially had very little acquaintance with the European community, was not particularly enthused about it. It took time for him to develop. He ultimately became a quite strong advocate of the European community, but not initially. So the constellation was not bright, you might say. 1985, a dramatic change. And it was a sheer coincidence, really, of that it should happen. A new commission president was to be named. There were a couple of candidates, probably the leading one being a German who had been commissioner for a while and would have been quite competent, I'm sure. But Jacques Delors had been the Minister of Economy and Finances in France. That's the top dog, and then under that is the Minister of Finance. And reshuffling of the cabinet, Mitterrand chooses Fabius, Laurent Fabius, bright young Turk, untried but charismatic. And who is Fabius today? You probably, some of you may know. He's the foreign minister. He has come back after a long time in the wilderness. He has come back. He is the foreign minister under Hollande. Any event, Delors was a personal friend of Mitterrand's. What to do about Delors? Delors is furious, very unhappy, talented, but what to do? Well, propose him as commission president. And Mitterrand is influential and persuasive, and Delors is chosen. Other coincidence, a secondary cabinet post held by a guy named Lord Cockfield. Thatcher does not want to send a heavyweight to Brussels. Pick this secondary guy. Send him off. Won't make waves. Well, of course, she was totally wrong. Cockfield has written a book on the internal market, which is absolutely fascinating. I don't think you can get it. I have a paperback. It was a paperback. And, you know, I dare say the Library of Congress has it, but I'm not sure that any of the libraries in New York City do. And he recounts how he was chosen, and he's very matter-of-fact about Thatcher's intentions, and how she was so annoyed when he didn't turn out that way at all. He had his own ideas. He was named the commissioner in charge of the internal market. The internal market was a name that had started being used in the late 70s instead of the common market. I've never liked it. I much preferred the common market, but there it is. And so he met with Delors before they took office in January of '85, and he outlined his ideas for the internal market. In fact, he drafted what became the white paper in large measure before he ever took office. Delors takes office in January. The Commission president traditionally presents an agenda to the Parliament in January. Delors' agenda, principal item, monetary union, not the internal market. The internal market is in there, but that's not Delors' real interest. Delors' real interest is monetary union. But Cockfield is interested in the internal market, and Cockfield is persuasive, and Delors has no objection. It's ironic that Delors is given all the credit and Cockfield very little when in fact it was the other way around. So the European Council had, under Mitterrand's instigation at Fontainebleau, urged reactivation, and the Commission drafts the white paper of June 1985, completing the internal market. This is Cofield's handiwork, and you can see it's a Brit's handiwork. It's very pragmatic. First of all, it's called a white paper. This is British terminology. A white paper is a program for action. A green paper, a thought paper. We're thinking about this, here are possibilities. White paper, program for action. It sets out the goals: complete the internal market, break down the physical frontiers. Not only goods, heavy emphasis on services and establishment, where not much progress has been attained. Fields that have been blocked for years, we're going to go into: banking, intellectual property. And amazingly, the European Council endorses. The media finds it exciting. The governments, including the UK government, Margaret Thatcher says, yeah, we're better at making products and providing services. We can benefit from this. She supports it. And it becomes a program that has real chances. I read it. I was teaching. I read it in 1985, and I can tell you, I thought, oh, another of these commission documents. And I was quite wrong. Within a year, it was a very real program. By the late 80s, second banking directive, new securities regulation directives, the directive on recognition of trademarks, other directives. The program is moving. It was just astonishing how fast it worked. And it was time fit for Delors' 2 terms. They expected 2 terms, 8 years. So 1992. 1992 becomes a catchword. By December 31st, 92, we're going to do it. The European Council at Edinburgh in late 1992 says 95% achieved. And that was true. It was just extraordinary. Once you have the enthusiasm for the program, you have the possibility of treaty amendments to try and further the program and do other good things as well. This was a Single European Act. This is a very odd name. Why Single European Act? It's because they put into one document 3 different proposals. And they said it's a Single European Act rather than the 3 diverse proposals. One was internal market, one was environmental protection, and then there were some heterogeneous matters also that were put into the Single European Act. The European political cooperation, among other things. So it is proposed at an intergovernmental conference. This is the first time there's an intergovernmental conference. What is an intergovernmental conference? Have you ever heard of an intergovernmental conference? IGC, do you know what that is? An IGC is a body of the foreign ministers. Usually the deputies do most of the work. But the foreign ministers that meets for a concentrated period of time. The first one only met for 2 months. For Maastricht, it was a full year. And in the IGC, they formally prepared the treaty amendments. then of course the amendments have to be ratified by all of the states. So the Luxembourg IGC meets. The UK and Denmark are opposed. They do not want amendments. But fortunately, despite their opposition, they attend and actually work on the text. And that's an important precedent because later for the Treaty in Maastricht, the UK and Denmark are again opposed, and Greece as well. And nonetheless, they move ahead. The conference moves ahead. So the text is proposed to the member states, very quickly ratified, goes into effect July 1st, 1987. So it's the first serious amendments to the treaty. The most important part of it is that the Council of Ministers is stated to adopt by qualified majority vote the internal market legislation. Now that meant the Luxembourg veto would no longer be accepted. And quite surprisingly, that happened. The UK allowed itself to be outvoted on securities, SEC, what we call SEC matters, Securities and Exchange matters. Germany and Denmark allowed themselves to be outvoted on environmental quality measures. They wanted very strict measures on the emission of exhaust by cars and the expensive devices to achieve that. And they couldn't get it, but they allowed themselves to be outvoted. So the precedents were set that the Luxembourg veto no longer works. And the Commission in its annual reports said that. It said that in 90 and it said that again in 91. The Luxembourg veto, their member states are not trying to block a qualified majority vote. Commentators agreed. So this is the most important single modification in the Single European Act. A couple other things. I mean, environmental policy now comes in as a treaty sector. And the European Council formally is mentioned in the treaty, and it's how it's composed, the heads of government and the President of France as well as the Prime Minister of France. So there are some important achievements in the Single European Act, but it's not much, not much. Still, progress has been achieved in the internal market program. There's great enthusiasm now. Next step, Delors wants monetary union, and Delors is charismatic. He convinces the European Council to make a study, and he is the person who chairs the gathering. All of the bankers, the central bank governors, are the committee plus a couple of economists. And surprisingly, they are unanimous. They provide a unanimous report, the Delors report, April 1989. And the report is the planning for monetary union. European Council endorses it. Next step, an intergovernmental conference to amend the treaty. Simultaneously, enthusiasm for modification of other parts of the treaty. And the European Council endorses that at Strasbourg in December '89. December 1990, the Rome European Council, the meeting is launched. And it lasts not quite a year under the Luxembourg presidency and then the Dutch presidency. Interesting, the treaty doesn't say anything about presidencies for an intergovernmental conference, but it just was accepted that the country who has the presidency of the council should likewise chair the intergovernmental conference. This is, of course, extremely important because there's the drafting that's going on and somebody is presiding over the drafting. Luxembourg and Netherlands you can't get more Eurocratic countries. If it had been Greece and Spain, for example, it might have looked quite different. So the Maastricht Treaty is drafted in 1991. I'll talk about the Maastricht Treaty in the next section, but it was not easy to be ratified. It had a difficult route. Here the roadblock, principal roadblock, was Denmark, because Denmark turned it down initially in a referendum. The European Council at Edinburgh tries to acquiesce to some of the Danish concerns. One of the Danish concerns is we want no part of monetary union. And they are assured on this. They also want no part of the security policy aspect of common and foreign security policy. They are assured on this. And that ultimately leads to a successful referendum in Denmark, and the Maastricht Treaty can go into effect November 1st, 1983. It had been signed in February of 92, so that shows you it took nearly a year and a half to be fully ratified. Another crucial factor was the German Constitutional Court judgment on Maastricht, which I won't go into. Constitutional Court, again, we are a federal country. You have to respect our structure. We ratified the treaty on the understanding that nothing in it, as implemented, is going to affect that structure. Okay. Same thing they said with regard to the Treaty of Lisbon. So that sets the stage for the 1990s. You will not get a major revision nor a major policy program implemented. I mean, a clear example is the Lisbon Agenda of 2002. That has gone nowhere because you can't achieve it now. There's no way of achieving it now. So you are absolutely right. And this is true in the US as well. It's very difficult to get a major policy initiative during a recession. 2001-03, early 90s, and currently. I've lived through 3 major recessions, the 81-83. It's almost every 10 years, 91-93, 2001-03, and now the more recent one. That's 4, I guess. Okay, let's turn to the late 90s and the start of this century, and I think that's where I'm going to wind up. Maastricht Treaty is a total restructuring of the architecture of the European community, and it launches the European Union. Let's talk about the restructuring of the European community. They dropped the word economic, which is perfectly sensible because the European community is far more than economic now. Institutions are the Council, apart from the qualified majority emphasis, not really much changed. But the real beneficiary of Maastricht is the Parliament. The Parliament directly elected in the 1980s is still not very important because all it has is the power to be consulted. True, the Single European Act added something called the cooperation procedure, which is now pretty much totally forgotten, and which enabled Parliament to slow down and influence legislation to some extent, but not a big deal. With the Treaty of Maastricht, Parliament attains virtual equality, the so-called co-decision process, and it's not a word that appears in the treaty. It's an awful word. I wish that it was not used because the students don't understand it. It's bizarre. Lisbon Treaty says the ordinary legislative procedure, which doesn't tell you anything, but at least it gets rid of co-decision. Parliament gets almost equality. Now, the Treaty of Amsterdam 1999 gives it total equality. What does that mean? The Commission is still the instigator. Nothing happens until the Commission decides to put in a draft. The Commission still controls the wording of the drafts. But legislation goes through two stages now. A first stage where the Council and the Parliament are working pretty much autonomously, and both at lower levels, working parties in the Council, committees in the Parliament. Final review may be at the full level, but basically that's where it is. Then a second, much more formal stage, the so-called second reading, which is usually triggered when the Council comes up with its text, which is called the common decision of the Council, and the Parliament starts chewing on it. This time not only the committees, but the full Parliament. And it takes two to tango. Both must accept a text. Now, a final wrinkle which is very useful because it's used in about 1/4 of the cases. A conciliation committee, Council and Parliament, equal, same numbers, 1 week chaired by the Parliament, 1 week chaired by the Council. Let's try and work this out, get common ground. Overwhelmingly successful. Very rarely are they unable to come up with a final text. So if the legislation has progressed as far as sending it to the Conciliation Committee, and some legislation doesn't get that far, but most does, then the chances are very good. Very rare that it fails. Only once or twice has the Parliament vetoed afterwards. The biotech patent and the 13th Company Takeover Directive. Parliament vetoed both at the very end. Well, company takeover, it was a tie. And both came back in slightly altered form. So it's been a successful legislative process. Now my students, I put this on the board and arrows here and arrows there and so on, and they hate it. And so I'm no longer doing that. I'm no longer putting on the board. But, you know, do you understand how the House and the Senate waltz around in order to adopt legislation? I mean, it's incredibly complicated also. So it's not surprising that you should have this complicated procedure. What else does Parliament gain? Parliament gains some other powers, in particular the assent power, now changed to the term consent by the Lisbon Treaty. I don't know that that really matters. Most important assent, new member states. Parliament must vote by an absolute majority. In other words, you know, like any legislature, it's hard to get a quorum already, but a majority of the quorum doesn't cut it. It has to be an absolute majority of the Parliament. Must vote in favor of the new states. All right, Austria, Finland, and Sweden, no problem. Central Europe, there was some anxiety about some states, but ultimately Parliament did vote in favor of everyone, and each one separately, by the way, each one separately, differing votes depending on the country. Parliament, if ever, the Commission and the Council could succeed in negotiating accession for Turkey, I'm not sure Parliament would accept Turkey. I used to say that Turkey would not come in, at least before I retired. I'm now categoric. Turkey will not come in my lifetime. Maybe sometime, but not in my lifetime. And that could be true of some other countries as well. I'm not sure that FYOR Macedonia can come in because of Greece, unless Macedonia agrees that it cannot be called just Macedonia, but has to be called the former Yugoslav Republic of Macedonia, which is what the Greeks insist. So I just don't know. But conceivably other countries will come in down the road. Parliament also has the power of assent over some types of international agreements. It had to assent, for example, to the WTO after the Uruguay round, because some provisions would modify legislation on which Parliament has co-decision powers. Parliament refused to accept one of the association agreements with Israel at a point in time when they thought Israel was not properly treating the Palestinians. That was later modified and Parliament later accepted. But it was pretty important in the 1990s for Parliament to say, we're not going to do it. So has some other assent powers. In practice, more important by far is supervision of the Commission. That started coming in Maastricht. It was reinforced in Amsterdam and Nice, the treaties of Amsterdam and Nice. Amsterdam effective May 1, 1999. Nice effective February 1, 2003. Parliament gradually gaining. So let me tell you what it is at the end of the day rather than at the start. At the end of the day, first step, selection of the President of the Commission. European Council now makes that nomination. And the Treaty of Lisbon says by a qualified majority vote. Well, wait and see. I say wait and see because in 95, in 99, in 2004, each time one or two favorite candidates vetoed by a big member state. Lubers of the Netherlands vetoed by Germany. Lubers apparently had not been sufficiently supportive of German unification. Prime Minister Verhofstadt of Belgium vetoed by the UK, too European, etc. So wait and see whether there is going to be a Luxembourg veto or they will actually choose by qualified majority vote. Barroso was a compromise. He was a compromise. There were two other candidates. Well, one you probably know, Tony Blair. And they couldn't get unanimity. So first choose the president. Then the member states nominate each one a commissioner in accord with the president. Does that mean very much? Well, we don't know very well. Barroso made a big deal of trying to convince some countries to nominate women commissioners. The first woman commissioner was in one of Delors' cabinets. But there were very few until Barroso, and his first, he had 8, and now he has 9, which is about 1/3. And that obviously is a major step forward. But apart from that, he apparently has not had much influence on member states. He apparently did get the UK to back off on somebody of lower quality and push for somebody of higher quality. I can't remember whether that was 04 or 09. So, okay, now we have the nominees for the commission. The Parliament must approve the commission quote, as a body, votes for them all at once. But in '95, Parliament tried a ploy and it worked. Parliament requested every candidate to come before an appropriate committee for a confirmation hearing, and they all agreed. And it's not in the treaty, but it has happened ever since. So in the confirmation hearings, they can investigate the experience, the qualifications, and the views. Now, 95, fine. 99, crisis. Sorry, 2004, crisis. Why? Because the Italian nominee, this was a conservative leader of one of the coalitions that was indispensable for the government, in his hearings was undiplomatic, particularly with regard to his views on women and on homosexuals, gays and lesbians. And the committee said unqualified. They also, two other candidates, there were problems, but one, Latvia withdrew the candidate, submitted another, and the other was switched to portfolio Kovacs for Hungary, and it worked. But Buttiglione, the government would not withdraw the name. And should have been a vote on November 1st, no vote. Barroso hangs tough. Week passes, 2 weeks passes, 2.5 weeks pass. Barroso says he's going to go to the parliament. He is told by the leaders of parliament he will not get a favorable vote. Barroso goes to Italy, withdraw Buttiglione. They nominate Frattini, the foreign minister, no problem, in. But this is not in the treaty, it's custom now. Parliament can block a individual commissioner. This happened again in 2009 as to another proposed commissioner. So custom added to the treaty, increasing Parliament's power. However, even more important, the power of censure. Curiously, and I didn't know this until I wrote this first part of my paper, this is in the initial treaty. It's in the EEC treaty, 1958. The power of censure. Nobody talked about it, but it was in there. What is the power of censure? Parliament, by an absolute majority, can compel the resignation of the Commission, all of them. Has Parliament attempted to do that? 9 times. There is an excellent book about the Parliament written by a British MEP, and he has listed 7, and since then there have been 2 other occasions. None of them came very close to winning, except the mad cow one. Does anybody remember mad cow disease? 1990s, terrible, terrible. And it came from eating the brains and other organs of diseased cows. And the Brits had the problem, and there was an embargo on British beef until the Commission said it was safe, and Parliament wasn't sure the Commission had been properly careful in saying it was safe, so they threatened to bring down the Commission. It didn't win, but it was close. 1999, the unhappy Santerre Commission Santerre Commission was not a do-nothing commission. It did a lot. It was very effective in many areas, continuing internal market program. But in 1998 and early 99, reports of corruption, particularly in infrastructure aid and agriculture. And it was serious. And there is now a body that investigates that kind of corruption. But also concerned about individual commissioners being engaged in what was called maladministration, particularly the French commissioner Edith Cresson and the German commissioner Monica Wolf something. The commission decides to appoint a top-level three-member committee of wise men to investigate. One is a former Advocate General of the Court, whom I happen to know rather well. Committee issues a scathing report. It agrees that Cresson has engaged in maladministration. It clears the German. And the Parliament says, we're going to censure. The committee report is delivered to the Commission. The Commission meets the entire evening. At 2 o'clock in the morning, it resigns. Santerre Commission resigns. Because it has been assured by the Socialists and the European People's Party they will vote in favor of censure, and it does not want a precedent of a censure, so they resign en masse. But the handwriting is on the wall. The Parliament will censure if it really thinks that it's imperative to do so. So that is now a sword hanging over the head of any future commission. Anybody know the follow-up on Edith Cresson? By the way, the problem for Cresson was very simple. She had been the first woman prime minister of France. The French government said, you will not, under any circumstances, force the resignation of a former prime minister. You will not. And so the Santerre Commission couldn't do anything about it. Was she guilty? Yes. Yes. Famous example. Her dentist got a $100,000 compensation contract for writing a paper about which she knew nothing. Court of Justice reviewed it, said she was guilty of maladministration later on because the commission said you can't get your pension benefits, so she sued. Court of Justice had the case, plenary case, all the judges. Cut her pension in half. All right, but it's clear she was guilty of maladministration. Lisbon Treaty amends. The president can compel the resignation of a commissioner so that won't happen again. All right, but it's a terrible, terrible event. Prodi Commission comes in immediately, fills the end of the term, and then re-elected for a full term. What else is happening by virtue of the Maastricht Treaty? Citizenship of the Union is created. This is an idea that goes back to the mid-1970s, but hadn't gone anywhere. But Prime Minister Felipe González of Spain thought it was a great idea. And he pushed for it in the Intergovernmental Conference, and it's put into the treaty. What is citizenship of the Union? Any national of a member state, i.e. any citizen of a member state. Actually, national can include people there by virtue of not amnesty, asylum are nationals as well as citizens, but generally speaking, it's citizenship. So anybody who's a citizen of a member state is likewise a citizen of the European Union. What rights does it give? A couple of trivial rights: vote for members of parliament in the country where you reside, vote for local and regional officials in the country where you reside, not really very important. A right, an absolute right of residence in another country. That's important. Because previously that right existed for workers and for people who are established in another country. In other words, you go as a business person or as a doctor and live in another country, you have a right of establishment in that country. But otherwise, no. Now, legislation gave it the right to family members as well, immediate, up and down, family members, up and down. Not aunts and cousins and like. But now, anybody, retired, never working, the rich and the poor, have an absolute right to go and reside in another country. Limited, there is a limitation based on public policy, public security, and public health. And it means that in practice, based on on court judgments, a country does not have to provide social assistance for 3 months, the initial 3 months of residence. But apart from that, so this is a big deal. And the Court of Justice has, in a series of judgments, liberally, teleologically, activist judgments, expanded the rights. The most famous, the one that really amuses my students, is Shu and Chen. Ever heard of Shu and Chen? In Shu and Chen, a lady who is a citizen of Hong Kong, and her husband is likewise a citizen of Hong Kong. They want their child to be a European Union citizen. What does she do? She moves to Belfast to have the baby. Why Belfast? Because under the Irish law at the time, it's since been amended, any baby born to non-Irish parents in all of Ireland, not just Ire, but all of Ireland, Northern Ireland, is a citizen of Ireland. So she gets Irish citizenship for the baby. She then moves to the UK. Well, she's in Northern Ireland. She moves to proper UK, central UK. And says, my baby is a UK citizen, is an Irish citizen, therefore has the right of residence in the UK. My baby can't live on its own. I have a right as caretaker. Court of Justice says, yes. The caretaker of the infant, until the infant is an adult, which could be 18, could be 21, but in any event, until then, the caretaker has a derivative implied right to stay with the child because it's the best interest of the child. So that is the most expansive judgment on the right of citizenship to date. Of course, Catherine knows of a couple others that go in the same line, but that's the most delightful so far as I'm concerned. Okay, citizenship. I don't think I need to talk anything more about the European Community Treaty. The Treaty on European Union. Why a Treaty on European Union? When the Luxembourg Intergovernmental Conference is being held, some countries want to expand European political cooperation and bring it into the community. And they also want to start working in the area of justice and police. And other countries don't want to do that. And so pillars are conceived. The Netherlands tries to bring it back under the same roof. No, that doesn't work. Their draft is rejected. Go back to the Luxembourg draft, separate pillars. So, although the European community moves on, there is now a treaty intergovernmental structure. The institutions are not involved directly, only the Council. And the Council is working intergovernmentally, not federally or supranationally. No QMV vote directly. And that's necessary because some governments will not accept bringing it under the community head. So that is put into place by the Treaty of Maastricht in 1993. Between 93 and 1999, it's only 6 years, Treaty of Amsterdam. So much progress is made in the field of cooperation and justice in home affairs. Conventions are adopted, the Europol is created, that it's decided to bring all of that but criminal and police into the treaty proper. So into the community proper. So that happens in the Treaty of Amsterdam. Lisbon, all of it, even police and criminal court cooperation. So you have now, for example, the European arrest warrant and the procedures under that. You have anti-terrorist measures. You have drug and criminal activity limitation measures. That is all now European Union proper. Some safeguards, some European Council special intervention, but basically it's all in. Cooperation in foreign security affairs, no dice. Slightly modified by the Treaty of Lisbon, slightly easier to get to the stage of qualified majority voting at the Council by virtue of unanimous voting of the European Council. I don't even teach that. I do not teach CFSP. I have never taught it because I don't think it matters very much in practice. Yes, you can continue adopting these resolutions, but that's about all you can do. The terrible tragedy of the Croatian-Serbian War and the Bosnian Civil War, they couldn't do anything about it. Yes, the European Council said sanctions. Yes, then the European Community, acting under provisions of the European Community Treaty, adopted economic sanctions against Serbia, and yes, that hurt Serbia. But ultimately, it was the US, acting through NATO, that ended the Civil War. And so, you know, when push comes to shove, they really can't do it. Are they doing anything in Africa? No, the French are, but not the European Union. So I really don't think common and foreign security policy warrants enough, is enough important that I teach it in class. Now, I forgot that I'm being recorded, so I hope that people will not take that amiss, but that's my view. It's not pragmatically as important as some of the other things. The big development in the 90s was enlargement. Austria, Finland, and Sweden, of which I've written an article, easy, no problem. Functional democracies, solid democracies, strong economic conditions, no problem whatsoever. Had to wait for the Maastricht Treaty, deepening before widening, that's all. Easily negotiated, easily comes in. Beneficial? Yes, in ways that hadn't been foreseen. Denmark, Sweden, and Austria all have strong views on the environment and protection of the environment, so there's been a reinforcement of those countries that want to push in that area. They also have strong traditions of transparency. Transparency entered the treaty in Amsterdam, a provision on transparency, and it has gone very far. All council votes, the council must, when meeting on legislation, the council must meet publicly, which means that it's televised. It doesn't mean that people are in the room, because I've been in that room. It's a football field. It's huge to accommodate all the delegations, but there's no room for the public. But it's televised, and the media are in an adjacent room. And they can reproduce that on television screens. The votes are recorded. All council votes on legislation are recorded. Abstentions are recorded. Statements are recorded. That's transparency. The right of access to documents, which is in the treaty since Amsterdam, has been widely interpreted by the court, first the General Court, the lower level court, and now the Court of Justice, to the extent, and this to a lawyer is startling, opinions of the legal service of the Council of Ministers on pending legislation before the Council can be obtained by private sources and published in the media. That, to me as a lawyer, is uncomfortable. Uncomfortable. But the court has so held. It has also held that some of the internal commission discussion in competition cases is likewise open on access to document basis. So it goes very far.
There's a formal procedure to apply for that? Like
Not the commission decision of taking in deliberation itself, but internal procedures of review and examination of documents. Back to enlargement. Central Europe. Oh boy. Well, you all remember 1990. The Berlin Wall comes down. The Central European countries are going to be free again. Who could have believed it? Even 2 years before, who could have imagined it? It was extraordinary. It was just so fabulous. Dancing in the streets. It's fantastic. But boy, trying to get up and running democratic governments, not going to be easy. European Council of Copenhagen in 1993 establishes the Copenhagen criteria for membership because they knew everybody wanted to come in. It's a magnet, draws them in. What are the criteria? Political criteria, functional representative democracies, rule of law, and rule of law means independent Supreme Courts or constitutional courts or both. Second, the economic criteria, functioning free market economies. Functioning, not just nominal, functioning free market economies. Third, infrastructure, administrative and all other infrastructure capable of adopting all the European Union legislation, which at that point fills volumes. There were estimated to be 17,000 individual legislative items that had to be adopted. It's just incredible, the amount that had to be done by virtue of Copenhagen, 93. Mid-road in the mid-90s, so-called Europe agreements, very close association agreements. Already people get some rights to move and work in the West. Already businesses have some rights to operate on both sides of the frontiers. European Council separately reviews qualifications. The Commission every year is examining in reports the qualifications and progress of each country. Each country, long reports. I used to read them, every report, November of each year. Great detail. 1997, December 1997, Luxembourg, 6 countries are ready to negotiate. Helsinki 2 years later, the other 6 ready to negotiate. By the way, Malta and Cyprus are the Mediterranean side, and they were in the first wave. Negotiations very laborious. Some chapters easy, others very hard. Environment, for most of the countries, very hard. Workers, establishment, very hard. Ultimately, as you all know, May 1st, 2004, 10 countries come in. Bulgaria and Romania, which have weaker economies and more corruption problems, come in 2 years later, 2006. Commission was not happy when they came in 2006, principally because of the corruption problem. And they had a penalty applied for a year as to agricultural aid and infrastructure aid because of the corruption. But even today, it's a very serious problem in those countries. And in some others. It held up Croatia as well for a while. And what can you say? It's an endemic problem. I mean, look at government in the United States. It crops up from time to time virtually everywhere. So that was the great development. We leaped from 12 to 15, easy. 15, 25, 27, now 28. End of the road, well, for the near future, I think. Iceland, at the time of its monetary crisis, applied. Commission said yes, negotiate. Negotiations started. Banking crisis over. Iceland suspended negotiations. I don't think they'll join. Might, but I don't think so. Serbia, Albania, Macedonia, Montenegro, all interested. Macedonia actually applied. No action likely. Maybe 5 years from now, not in the near future. So at the moment, it's 28, and I think it'll stay 28 for a while. Well, as I said, I think that most of the rest is contemporary, and I don't need to get into it, and you probably know just as much as I do about many of these current issues. Turkey, not a serious applicant at the moment. Quite apart from the Kurds. You know, I attended a conference of the European Studies Association of Canada in Montreal some years ago. This must be 10 years ago. And there was a delegation of Turkish academics there, and they had a program about Turkey's application and so on. And I said, you know, is it possible that Turkey would grant autonomy to the Kurdish region? Answer, no. And then I said, well, in that case, you will never join the European Union. I mean, to me, it's quite clear that they have to grant autonomy to the Kurds, quite apart from the Cyprus problem and their support for the Turks in Northern Cyprus. You know, a strong Turkish government could withdraw those troops and say, too bad, we want to join the European Union, cut a deal with the Greeks. A strong Turkish government could do that. But if a strong Turkish government cannot grant democratic autonomy to the Kurds, I think it's out. I think it's out of the question.